going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great day so far. Got a good one, a little bit spicy. This is Judge Clark out of Florida, Bay County, Florida. All right. Anyways, this defendant tries to get rid of his attorney. He fails. He mouths off. He gets yelled at. Then he goes pro se. It's pretty much the entire video, but it's fun to watch. All right. Before I hit that play button, you know what to do. Hit the like and subscribe to your jump kick backflips. Let's go.
Morning, Your Honor.
Good morning.
Mr. Davis. Our Chris Scott here on behalf of Michael Davis, 23-445 and 23-359. Yeah, Your Honor, obviously we're set for trial this week. I believe that Mr. Davis would like to address the court.
Mr. Davis?
Yes, sir. Me and my counsel are having some irreconcilable differences, sir, because if I can show paper.
What are you getting ready to ask me today?
Sir, I'm ineffective assistant counsel, sir, so we're arguing.
Where Mr. Davis in, please?
Yes, sir. Do you solemnly swear or affirm testimony about to speak the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Mr. Davis, are you asking for another attorney today?
Yes, sir, because I have
Go ahead, put your grounds on the record.
documentation, sir, where police say they had, right here, the police say that they turned evidence in, and I wrote the Bay County evidence custodian, and they said evidence was never turned in. This is exculpatory to my case because my whole case revolved around a phone call that they never had. The officer stated that he turned it in. I could show paperwork where he turned it in, and then he turns around and contradicts it and say he never turned it in. He accidentally ran this conversation over and destroyed it. By the conversation being destroyed, and if I could prove it, if they never destroyed it, sir, I can't impeach him because it's contradicts what he's saying. It contradicts what he's saying. It's like if you're blatantly intentionally falsify legal documents, which is like police misconduct, I could prove that there was never a phone call. It wasn't me on the phone call. They executed a search warrant and swatted my car in the middle of the road and came up with some false allegations on the reason why they did all this. Then that he ran the evidence over, Your Honor, is exculpatory for my defense because it shows that it's prejudice. Like my counsel can't represent me. I'm asking him to file a motion for a discovery violation, and he tells me he refused to file a motion for a discovery violation. I asked him for a Richardson hearing. He told me he refused to file a motion for a Richardson hearing. I told him that they have no probable cause to ever stop me from suppression issue. He refused to file a motion for a suppression issue. Only thing he's telling me is take a deal or go to trial. He hasn't talked to me about no type of defense he will put up in trial. Only thing he's screaming, take a deal, or I can't represent you, and I'm not filing no motion, and I can prove that you ran over evidence that you say you turned in, and there's a law that none of this evidence was ever turned in. So beginning to the end of my case is being prejudiced, and the officer is acting in bad faith because he's intentionally and knowingly falsifying documents and trying to let it come back around and loop it all in and present it in my case, Your Honor. My lawyer won't do nothing for me. He refuses to do any motion and fight. Do anything for me. All we do is bump heads on when I ask him questions and I show him evidence, and everything I show him, sir, he done read is like, and he won't do nothing about it.
All right. This is a interesting issue if it's true. Now, big if the attorney's not filing the motions, then there's a reason why it's not filing the motions. But if a warrant was signed based on a phone call, I'm guessing they had it tapped or it was recorded by somebody in the police, so they had to have had it. Otherwise, they wouldn't have been able to issue the warrant based on a phone call. Now, let's just say that's true. Warrant gets issued by signed by the judge because of this phone call, and then it turns up this phone call isn't there, that it's just automatically gone. That makes the warrant invalid, and then he got pulled over. He's in jail based on that warrant. That's a very interesting legal battle that I would like to see how that would be figured out. I really would. But again, if the lawyer's not filing these motions that would make sense if that was true, then there's a reason for it. All right, let's keep going.
Your Honor, it's true that there are inconsistent statements and inconsistencies in the discovery and the evidence. However, Your Honor, in my review of the file, to file any sort of motion per Mr. Davis's wishes would be frivolous and waste the court's time. I've explained to Mr. Davis that, in my opinion, I don't have grounds to file these motions. And I've explained to Mr. Davis the things that he's arguing are good points, but points to be argued at trial. I find no discovery violation, no evidence of any discovery violation, no evidence that any sort of evidence was intentionally mishandled. What Mr. Davis is referring to is that a recorder that had allegedly had a conversation on it was run over by a police car, and that recorder was destroyed. But I find nothing to show that that was done intentionally. We deposed the officer on this, nothing to show that it was done intentionally or with any kind of malicious intent or any reason to give grounds to file a motion, Your Honor. As far as the ineffective assistance, Mr. Davis and I have talked these things through several times, and the conversation, he's right, we have some differences for sure. However, Your Honor, and I think I've explained it to him, he just doesn't like the explanation that I've given him. Thank you, Judge.
I'm gonna deny your motion to remove Mr. Scott as your attorney. I'm satisfied with his response. Just because you don't agree with the tactics of your lawyer does not mean he's ineffective. It does not mean that you're entitled to another lawyer, a court-appointed attorney. So I'm gonna deny your motion at this time.
So you trying, so.
No, sir, I've already made a ruling and I've explained it. No, sir.
We're going through it and
Mr. Davis, that concludes your hearing. That
he railroad me like on some Jim Crow all type stuff.
Mr. Davis, that concludes your hearing.
I don't care about that.
Sit down.
You let the man
Mr. Davis,
railroad
that's
me.
enough. I have made my rule.
And Your Honor, I believe we're waiting to see if another case resolves, whether we're going to move forward with trial. Very good. Thank you, Judge.
Mr. Kennesaw, looks like we're gonna have at least.
Oh, I forgot to fade in and fade out. This is about, I don't know, 5 minutes later. He didn't stop talking. He was in the jury box just talking, but you couldn't hear what he was saying, so I skipped that part. Anyways, they're going to bring him back up now because, like I said, he doesn't stop talking. Anyways, yeah, I don't remember what I was going to say now because I didn't do the fade and fade out. Let's finish this video up. There's only about 2 minutes left.
Your Honor, what that is, I would request that it's set out to the next available trial week.
September 30th or
Yes, Your Honor.
September 30th at 8:30.
Thank you, Judge.
I'll go ahead and take Mr. Davis in the back.
Control, anyone removed from Alpha?
Man, I wanna go pro se.
All right, hold on, just wait here. You're already sworn in, sir. You're asking to represent yourself?
Yes, sir.
All right, Mr. Davis, you're asking to represent yourself. How far did you get to school?
You see how fast Judge Clark just accepted that when the defendant said it? It's like, I'm tired of you. You want to go pro se and ruin your case? Go ahead. I understand why he's frustrated. Like I said, especially if everything he's saying is true. Even the lawyer said there are some inconsistencies that don't make sense, and he just put it on the record that the officer ran over the recording. It was on a recording device. What is like little tape recorder thing that they used back in the, I don't know, 80s and 90s in police interrogation rooms? That's weird that they have anyways, I don't know. I don't know the facts of this case. It just seems like a mess. It really does. So I understand why this guy's frustrated. Going pro se is not the right way to go, though. Filing those motions is not going to help you right now. The attorney just explained why on the record. All right, I'm going to let this video play out. I've paused it too many times. You guys have a great rest of your day. If you haven't hit the like button already, please hit the like button, and I'll see you next time. Well, no, that's not what I say. Until next time, bye.
I graduated,
Okay, and what do you do for a living?
roofing.
Okay, and you can read and write?
Yes, sir.
Have you ever represented yourself before?
No, sir.
Okay, and you understand that lawyers are trained in the rules of evidence, criminal procedure, and the law, and you'll be held to that same standard.
Yes, sir.
That I cannot give you any assistance. The state attorney cannot give you an assistance if I find you're competent to represent yourself. You understand that?
Yes, sir.
Are you under the influence of any
No,
drugs?
sir.
Right? Listen, wait for my question before you answer, okay? For the record, Mr. Davis just rolled his eyes at the court. That's not any way to act in front of the court. If you're going to represent yourself, you're going to have to maintain the appropriate decorum. You understand?
Yes, sir.
Okay. Are you under the influence of any drugs or alcohol this morning, which would impair your ability to make the decision whether to represent yourself or not?
No, sir.
Okay. Have you ever been diagnosed with a mental illness
No,
that would
sir.
impair your ability to make this agreement
No,
or
sir.
to understand representing yourself?
No, sir.
Okay. I'm going to find Mr. Davis is competent to represent himself. I'm going to leave Mr. Scott as backup counsel. Mr. Scott is not required to help you or assist you in any way. At any point in time, you can ask for an attorney, and I'll reappoint Mr. Scott, but up until that time, he's just backup counsel. Okay?
Yes, sir.
All right, we'll set this for a trial management on September. Where's our September trial management day?
20th, I believe, Your Honor.
25th? All right, September 20th at 9 o'clock for trial management. At any point in time, Mr. Davis, you can ask for counsel. That'll conclude the hearing for today.
Yes, sir. Appreciate it, Your Honor.
Yes, sir. All right, so we're going to Warner, Frazier,